You know, when you're a judge, you don't go out to search for cases to get them brought to the court to make legal points. You sit there and you wait. The cases come to you. And there are lots of surprises. And one of the most fascinating cases I had in my 15 years on the Constitutional Court, we call it the Doctors for Life case. Doctors for Life were I don't think they'd mind the description, a conservative, pro-family, anti-abortion group. And had appeared before us in other matters, but brought a case that at first was startling. Parliament had passed a cluster of cases dealing with medicines and access to medicines and medical care. And one of the cases dealt with termination of pregnancy, abortion, and the law now that was adopted in Parliament, passing through all the different processes of telling the public the law is going to be there, presenting a draft for comment, allowing people from the public to sit in on the public proceedings, the voting, to make representations to the Portfolio Committee. It had passed through the National Assembly. It had gone up to the National Council of Provinces and been passed by the requisite majority. There was another law that dealt with, I think, the Association of Medical Practitioners, Dentists, very technical. And the third one, much more far-reaching, dealt with traditional medicine and recognition of traditional medicine. And all of these had been accepted in Parliament with the requisite majorities, signed into law by the President, and Doctors for Life put up their hands and said no. They said no. We made representations at the National Assembly. They weren't accepted. Okay. You win some, you lose some. But then we wanted to make representation to the National Council of Provinces as well afterwards. And they said, you don't have to come to Cape Town. We're going to visit the different provinces. We'll come to you. So we're waiting for them to come to us. And then we get another indication, sorry, but we've run out of time and we can't follow through with what we'd indicated, and the law was duly passed. And Doctors for Life said, but hang on, the Constitution says that the legislature must take reasonable steps to involve the public in all legislative processes. And the Constitution says, this is in the Section 1, the foundational principles, that the following values are foundational: universal adult suffrage and national common voters' roll, regular elections, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. And taken together, that means you've done us down. You promised us a hearing, we didn't have the hearing, and we are saying that the law is invalid. Now I must say, I'm reading this, and I think it was clearly inappropriate to promise hearings and not to follow through. But what can the court do? Say, naughty, 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 don't do it again. And we debate the issue. We're sitting around the table, and my colleagues are saying no. The Constitution requires reasonable steps to involve the public in the passing of legislation. adoption of legislation, for open, accountable government. And it's not enough to say, naughty, naughty, don't do it again. And this raised the question very sharply for us now. What is envisaged by our Constitution? Is it simply representative democracy in which Parliament is chosen through elections that are free and fair and regular, common voters roll? And every 5 years you have a chance to change government? Or is something more required? Does the Constitution actually require participatory democracy? And we debated the remedy. It wasn't simply stating a principle. Should we declare a law that's been passed by the duly elected representatives of Parliament, following all proper procedures with the requisite majorities, requisite opportunities for people to make representations during electoral processes and so on? They can sit up in the gallery and see everything that's going on. They are involved in that sense. Can we actually strike down the law as unconstitutional? And ultimately, after long debates and discussions, by a very large majority, the court said, it's not enough simply to say that it would have been better had you followed through on your promise to have public engagement. You have a duty to take reasonable measures, and you thought it was reasonable to tell the public, don't come to Cape Town, we'll come to you. It's then unreasonable to renege on that simply because of parliamentary timetable problems. We actually struck down the law. I might say, in terms of, if you can call it judicial emotion, an emotion you have as a judge in terms of impact and fairness and so on, I felt a very strong sympathy for the rights of the traditional healers to be engaged with in the provinces, on the spot. Traditional medicine is so local. It's the local bark and rivers and stones and waters. The people are not well represented in the political parties. They're not part of the political game of organized structures and so on, but very important sections of the community. And now for the first time they're being recognized as healers, not as charlatans, not as crooks, not as funny superstitious people, but being taken seriously. And this is really the kind of case where Parliament should go out and get local people involved, not simply to get their knowledge and wisdom, but to make them feel recognized and part of the process. And it's particularly important for the outlying groups, if you like, outlying in the sense of they're not well represented, they're not strong in terms of the formal structures of power. Democracy is so much stronger when groups like that are involved. The technical aspects for I think the dental community, I don't think anything in particular was lost there. And Doctors for Life, whatever one's own personal views might be in relation to abortion, if a promise is made to them, you've got to follow through with the promise. So it was Sandrine Ngobo who wrote the judgment for the court, and it's a beautiful judgment. He did an enormous amount of research. We all did research. And the research was on the importance of participatory democracy. It's not a choice between participatory democracy, where the public assemblies decide everything all the time on the one hand, or representative democracy, elections every 5 years. The way I put it in my concurring judgment is it's not like Sleeping Beauty. You have elections, you go to sleep, democracy, for 5 years until the next elections, you're kissed into life again by the new elections. That's not the democracy that's envisaged in our Constitution. And it's particularly important for the multiplicity in our very diverse society of different groupings to feel we might be in the majority, but we're important. We are people. And we should have our say, and we should feel involved, and we should contribute. And it produces very positive results. It's not simply fairness to the electorate and accountability. You get better outcomes where people are knowledgeable about the law. They've been engaged in the formulation of the law. They've been listened to. They feel part of that wider society. And that's what's meant by unity and diversity. It's not just unity or uniformity through a mathematical majority in Parliament at a particular moment. It's a unity of participation, of involvement, of feeling that you matter, that your views are important, and you're more likely to get outcomes that will work because the people on the ground who are most affected by the law have had a particular say. In my own case, I can acknowledge that I came on board with the remedy reluctantly. We'd fought so hard for the vote for Parliament representing the whole nation. And to strike down a law that had been passed with the requisite majorities and so on, that was hard. But I ended up totally persuaded that if participatory democracy envisaged by the Constitution is to be real, it's not enough to say naughty, naughty, don't do it again. There have to be consequences. And it wasn't an undue encroachment on Parliament in terms of what reasonable measures are, because Parliament itself had offered the meetings and said, you don't have to travel all the way to Cape Town, we will come to you. And I think that's the theme that was underlined by the decision in that case. And there's no other country in the world we could discover where the top court had actually struck down legislation for failures of participatory democracy. The nearest we got to that was in Portugal in the post-dictatorship constitution of the 1970s, to give the labor movement that had fought so hard against the dictatorship a strength of resilience and continuing power in the new society. It was necessary for certain consultations outside of Parliament with the labour movement to take place before a law could be passed. And I think a law was struck down on the basis that consultation hadn't happened. But that was something express, particular requirement in the Constitution itself. That was the closest we got to finding precedent for a participatory democracy. But also what became clear from the literature all over the world, there's a feeling that formal representative democracy is not enough, that there's a certain disenchantment with the political processes that have the elections, promises are made, not necessarily fulfilled, the people feel disempowered, young people dismissive of the whole electoral process that can lead to very, very negative results. And a yearning for continuing public engagement in the democratic processes, in the, not simply issuing papers and saying you can have, if you come to Parliament, you can have your half an hour or hour, whatever it might be, to speak to your representations. Something more on the ground, something more ongoing, a more visceral, if you like, organic connection between Parliament and the people. The Constitution starts with we the people. It doesn't start with I the President or we the members of Parliament. It's we the people, putting the people in that sense at the center of the whole project, not simply in terms of the imaginary as a notion, but as a lively source of positive fermentation.